Good morning. Are you Karis Antoine?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Judge.
And I'm guessing there's a warrant for what?
His bondsman surrendered his bond.
Okay.
And honestly, we thought it was something that was taken care of. They had contacted me. I actually got in touch with Mr. Antoine. He spoke with him, but
Okay.
Yes, because I talked to him Friday, and
Okay. That's good. I just wanted to make sure. You're good. Okay. And he'll waive the formal reading of the indictment.
he does, Judge.
Mr. Antoine, in cause number 24 DCCR 1878, you're charged with the third-degree felony offense of injury to a child from September 26th of 2023. And how do you plead to that charge?
okay, good.
You either did it or you didn't do it, guilty or not guilty. Are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Antoine is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report, and that'll give me more information about you and your case, and then we'll come back later for sentencing. So, with regard to a bond based on the nature of the plea agreement, Mr. Nichols,
I don't have any objection to that, Judge. He has no felony history that I see.
right? Let me look at this affidavit real quick.
The charge itself is for hitting a child with a belt, over discipline, essentially.
Okay. What's the status of that relationship? Do you still live with that child?
I haven't been around him since the case went.
Okay.
I do see him. I see him with my mom,
Supervision.
her mom,
Okay.
and I really miss my family.
Well, and we'll see how that goes on probation. For now, you're still under that order to have it only supervised, okay?
I understand.
And then you can work up once you're on probation, hopefully to doing the right classes and everything, and that should be lifted. What I'm going to do, Mr. Antoine, is reduce your bond in your case to $1,000, and I'm going to make that a personal bond. So I think that means, though, that he still has to go, right? Okay. So you're still going to have to go, but as soon as you get to the jail and they process you, you're going to be released without making that bond that I set because of the bondsman getting off your bond. Okay? Makes sense? It's just, but here's the thing. I'm kind of putting myself out there to make sure that you're going to do all the right things between now and sentencing. Okay? You have been until then, but it looks like you had some issues at some point communicating with your bondsman. It's very important, several things that you have to do between now and when you come back for sentencing.
I got you.
Once you're released from jail, you're going to get some paperwork today. It's going to have where probation is. You have to go straight to the probation department, okay? If you get released for some reason later this afternoon and it's too late, then you go first thing tomorrow morning.
Yes, ma'am.
If you don't do that and get that process started for that pre-sentence report, I don't have to accept this plea agreement. So things could be a whole lot worse. Do you understand? If you violate your bond condition and you're around the children or child that you're not supposed to be unsupervised, then obviously I don't have to accept this. Things could be worse. So keep following all of the rules of your bond. Yes.
I have one question. Okay, is it only for that child?
No, at this, I don't, I would say at this point, it needs to be all of your children, and then we'll deal with everything when we come back for sentencing, okay? And so that's for everyone, just to make everybody, well, it's not for everybody, it's for me to feel more comfortable until I get the pre-sentence report and I see what all is going on, how many kids you have, where they live, what the situation is, what the recommendations are from probation. So we're only talking about 5 or 6 more weeks.
Yes, ma'am.
But it is
I really have something important to tell you.
What?
I've been raising my 10-month-old for months by himself. So if I have to give him up, I will, because I need to stop it for my kids.
Well,
He's a baby. He's been with me since 12. Like,
who, where's the mom?
we don't talk. Since the case going, we don't talk like that. Like my mom and her mom, that's when we meet up. But
I think the court's question is the mother of the 10-month-old the mother of the child in this case?
yes,
So where's the child that was in this case live?
she's with her mom. I don't see them like that. Like we've been separated since I had been arrested, and she stayed with her mom, and I have my own place.
Okay. But it's the same mother of both of your children.
Yes, ma'am.
But the baby lives with you
Yes, ma'am.
and the other child lives with her.
Yes. She got 4 other kids live with her. I just got one.
Did you go through anything with CPS as far as they were I mean, we have an order for some CPS records, but was there anything, did CPS get involved?
I never went through nothing like that.
Okay,
I don't think anything's been provided to us in response to that order.
it doesn't look like it.
So
So maybe that's because there wasn't anything.
Yeah.
I think it was important that I tell you that I have.
No. I would much rather you be honest, but and if you're raising, let me look at something real quick.
No.
It's just, and just to clarify, the child is, in this case, not his biological child.
Okay. So how many biological children do you have?
3.
No, with her.
Oh, 1.
Just
One with that. Where you, and then the other 2, or where are they?
They're all with her, and all my other 2, they're with their moms.
With their moms.
Yes, ma'am.
So this is the only one you have. So there's no big deal. I mean, obviously, you love your stepchildren, but that this isn't your own biological child that's the
Right.
subject of this case.
Right.
Okay. Then what I'm going to do as a condition of your bond is order that you not have unsupervised contact with all of the children except the one that you're raising. Okay. If you're raising that child, I'll allow you to continue to do that. You'll get out, make sure that you follow all of those bond conditions. The last thing I was going to tell you is that as a condition of this, if you are arrested for anything between now and when you come back for sentencing, again, I don't have to accept this agreement. Things could be worse. You understand? Okay, we'll see you back at sentencing.
Thank you, Your Honor.
Thanks, sir.
Thank you. Good morning.
Good morning.
Good morning. And sir, you're Larry Fletcher Jr.?
Yes, ma'am.
And Mr. Fletcher, in cause number 25, DCCR 0838, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from September 18th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
In cause number 25, DCCR 0839, you're charged with the second-degree felony offense of manslaughter from September 18th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years. Do you understand? And then finally, in cause number 21, so we've got a motion to revoke probation in that one. Okay.
What I do is just go through the motion at this point. I think Mr. Holmes said that he would rather proceed on the MTRP first.
Well, the MTRP is based solely on these allegations.
So it would be a whole trial.
Yeah. Additionally, if the MTRP was adjudicated prior to this case going to trial, arguably it could foreclose an application for probation by the defendant, so.
That, I'm not worried about that, because if it, no, I guess I just don't want to. What level offense is that possession? Hold on a second, let me go back here. Second degree. Where's Mr. Coleman? To get ready. I mean, a lot of times I want to do the motion first, just because it depends on what the allegations are. I don't want to try to have to find 2 days for a hearing and hear all the evidence that we're then gonna have to turn around and potentially hear in a trial if it's not likely to be dispositive. One more thing, hold on. Yeah, on this one, I don't know that makes judicial economy sense. So what I'm inclined to do is set those for trial. But let me do this. It looks like the state has offered you in those 2 cases an 18-year term in prison. Mr. Fletcher, I have a plea bargain rejection that has your signature on it showing that, and that would be 18 years in each of those cases to run concurrently. Is that your understanding of what their offer is? And you understand if you go to trial again and you're found guilty, the range of punishment can be up to 20 years in prison. Do you understand?
Yes, ma'am.
I do want to go ahead and do this, and then let's go through the motion. I do want to get pleas of true or not true on that motion, and then what I'll do, Mr. Wilkerson, is get with you and Mr. Coleman in the next week or so. He's got a trial this week that he's getting prepared for, and I will make a decision on whether or not I'm going to go forward on the motion or if we're going to set those cases for trial first. But I want him to be able to have at least his argument in that, so we'll do it that way. So let me go through and find the motion real quick. And Mr. Fletcher, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Put your hand down. So in cause number, there we go, 21-37809. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 11th of 2021 for the 2nd-degree felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of manslaughter on September 18th of 2024, and is that true or not true?
Not true.
Count 2 alleges that you committed the offense of criminally negligent homicide September 18th of 2024, and is that true or not true?
Not true.
Count 3 alleges that you committed the offense of aggravated assault with a deadly weapon September 18th of 2024, and is that true or not true?
Not true.
Count 4 alleges that you committed the offense of possession of marijuana on July 4th of 2023, and is that true or not true?
True.
Count 5 alleges that you committed the offense of unlawful carrying a weapon on July 4th of 2023, and is that true or not true?
Not true.
All right, did you enter your plea of true to count 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to that count because it's actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your plea of true to count 4 freely and voluntarily, find that count true, find sufficient evidence to find you guilty and revoke your probation. However, what I'm going to do is reset this for now. Just make a note for me to decide what I'm resetting it to and put it on my desk, and I'll get an email or a call, Mr. Wilkerson, with you and Mr. Coleman within the next couple of days, and we'll figure out if I'm going to set it for a hearing and what amount of time that would need on the motion, or if I'm going to set it for trial on the new cases first.
Okay.
All right? And we'll stay in touch with Mr. Wilkerson and your bondsman, and they'll let you know when you need to be back, and he'll let you know what it's going to be for and all of that.
Yes, ma'am.
Okay? You're free to go. We need a print, please. Good morning. Are you Shay Brooks?
On the shot.
Shy, and Mr. Brooks, in cause number 24, DCCR 2034, was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle, received the pre-sentence report. Has everyone had an opportunity to review the report?
Good.
Stay there, Judge.
Any additions or corrections?
No, I'm good.
Nothing, stay there. The court probably be in the court.
Thank you, sir. All right, Mr. Brooks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you to a term of 10 years in prison, but probate that for a term of 10 years. You order to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have the felony conviction. Well, no, it's not. I'm sorry. You do have, for all practical purposes, your case here in court is over if you do everything you're supposed to. And you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you. Thank you. Paul McCorvey, Mr. Lewis. Good morning, you're Paul McCorvey, and this is 24 DCCR 1914. Mr. McCorvey's charged with theft of property, and what is the announcement?
Judge, we've gotten the transcripts and everything from probate court. This is
Okay.
going to have the probate
Yep.
matter going on.
Mm-hmm.
We have a potential resolution here, but I'm going to need to reach out to the probate attorney just to make sure that this will work. So we're asking for a short reset just so we can do that.
All right, any issues?
No, Judge.
Sounds like y'all,
There should
Billy's
be-
got the transcript now, so,
He's got it, and the resolution should be, I mean, we've got a resolution, but it's gotta be okay.
sure. Okay,
Right.
we'll just do, maybe 3 weeks?
That's good.
All right, we'll do a 3-week reset, and we'll get it taken care of on that date. Stay in touch with Mr. Lewis, he'll let you know when you need to be back. All right, your excuse, thank you. Good morning, are you Richard Robb? And Mr. Kimler, will your client waive the formal reading of the indictment?
So
Judge, with the court's permission, we're going to proceed on the lesser included class A theft with determined for his arrest.
All right, thanks.
and I've altered the judicial profession to reflect that now.
Thank you. All right, Mr. Robb, in cause number 24, DCCR 2170, the state has elected to proceed on the lesser included offense of a Class A misdemeanor theft from September 1st of 2024, and how do you plead to that charge?
Guilty.
Guilty or not guilty?
Guilty. So lesser included misdemeanor.
Okay, I'll hold it. Y'all go visit and make sure he knows what's going on before I go any further.
Judge, Mr. Fletcher represented to me outside. He misunderstood what you were asking with regard to the pleas of true and not true, and will of course embrace if he could change his plea of true to not true on the possession of marijuana allegation in the NTRP.
Mr. Smith, any objection to that? We're gonna have a hearing on all of it anyway. You are Christopher Thomas, and will your client waive the formal reading of the indictment
You will, Judge.
as amended on August 19th of 2025?
Correctly amended. We appreciate it. Thank you, Judge. And we have no, obviously, objections to the amendments.
All right, perfect. So, Mr. Thomas, in cause number 24, DCCR 1378, you're charged with the state jail felony offense of criminally negligent homicide from June 6th of 2023. And how do you plead to that charge?
Okay.
And are you pleading no contest freely and voluntarily? Ms. Malfino, does the state have evidence with regard to
I do, Judge.
culpability?
I would tender to the court and make it state's exhibit number 2, so it doesn't
Yes.
conflict with the plea papers, which is a report of Detective Thomas from Port Arthur Police Department. I would proffer to the court that on June 5th of 2023 on Highway 73 in Port Arthur, there was a traffic accident that occurred between Mr. Thomas. He was determined to be at fault in that accident. He was driving a semi-trailer and it led to the death of the individuals in the car. We have discussed this many times that there is obviously a big civil litigation pending in this case, so there is no probable cause after the affidavit. I'm assuming it was a direct grand jury, so I would tender her investigative report, Judge, which is just 2 pages, as states 2.
Any objection to states
We
2?
have no objection, Judge.
All right, states 2 is admitted. Mr. Thomas, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
I do.
And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like that agreement is for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand?
I do, Your Honor.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
We have no objection.
It's admitted. Is there any evidence that Mr. Thomas is not competent?
None at all, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll just give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Thank you, sir. Thank you for getting here, Ms. Ollie. I'll recall that bond forfeiture. Thank you for calling and let us know you were having issues. That's all it takes to not be in trouble. So this is cause number 25, DCCR 0532. Were you able to get a lawyer hired?
I reached out to Lone Star. I paid their consultation. I'm waiting on a call to see if an attorney will accept my case. I reached out also to James R. Macon, a criminal attorney, for their consultation and to get a full fee for this service. And then I reached out to Dewham and Jones Law Firm in Houston with their consultation and then to get a full fee for their service as well to take my case.
Okay. Thank you for doing what I asked you to. Are you able to afford any of that you know of right now?
Just the consultation.
Just the consultation. So I'm going to have you fill out some paperwork, Ms. Ollie, this morning to see if you qualify for a court-appointed lawyer since you've done what I asked you to, okay? You need to make sure and fill it out accurately and completely. Don't just leave it all blank. Put any income you might have, any bills you pay. You're going to swear under oath that it's all true and correct, and then I'll take a look at it, okay?
Yes.
If you step in front of the clerk right here, she'll give you that paperwork. Okay, all right, I'm going to reset Mr. Rob. Mr. Rob, I'm resetting your case for 2 weeks. If y'all get it taken care of before that court date, then you won't have to come. But if for some reason it does not get taken care of down the hall, you at least need to be here and y'all let me know where you're headed on it, okay? All right, you're free to go. And if you'll put on Rob, reset 2 weeks, and that's for a misdemeanor refile. If you'll make that notation, please. That's right. Good morning, sir. You are John Van Wright? And this is 24 DCCR 2485 and 15 23582. What is the announcement?
As far as the MTRP, it would be not true, Judge.
Okay.
I don't feel that you're not.
I think we'll just approve up the MTRP first, Judge.
Okay, so let's do this then. Let me get that pulled up. We'll go through that entire motion and then we'll get an updated report and set it for sentencing. Mr. Van Wright, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. And will he waive the formal reading of the motion?
Yes, Judge.
Mr. Van Wright, in cause number 15-23582, I have a motion to revoke your community supervision. Shows that you were placed on probation July 28th of 2020 for the third-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 10-year term in prison, but it was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of injury to a child, elderly, or disabled individual November 14th of 2024. And is that true or not true? All right, did you enter your plea of not true to count 1 freely and voluntarily? All right, then I'm going to enter that plea of not true on that count. I'm going to reset the case for sentencing hearing. About how long do you anticipate?
I want to know more than
About an hour or so, so we could do it maybe at the end of a docket? Sure. So we'll set it for 11, probably on a Monday, just at the end of one of these dockets, unless I can find a time when we're not in trial on another week.
Okay.
And that'll give y'all time for any
You can
evidence.
just let me know, or have Kelly or someone let me know so we can get witnesses here.
We'll do it. She'll be back tomorrow, and we'll get that set in the next couple of days. If I can get an updated pre-sentence report, that would be great as well. And then we'll see y'all back at sentencing. All right?
Good, Judge.
Thank you. We need to get his print, please. Good morning. Are you Alexandria Bledsoe? And this is 25 DCCR 0004. Ms. Bledsoe was previously in court and entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor. Yes, sir.
Any additions or corrections?
Only one minor thing my client would bring up. The name of her employer was Cigna, correct, or Sigma? Cigna, it was listed as Sigma, and she was just worried that might be an issue. I told her not to worry about it, but she wanted to bring it to the court's attention.
Okay, thank you very much. Anything else? All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include completing an intensive parenting class. If you haven't already done that through CPS, there's going to be something through probation that you're going to need to do, obviously. If you do everything that you're supposed to on this probation and follow all of the rules and conditions, then this is an excellent opportunity because you do not have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? Okay. Obviously, I would like to think that this was a huge wake-up call because this could have been very, very bad. And so take care of your child, take care of the classes, make sure you make all of the right decisions when it comes to that, and you shouldn't have any issue. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you, Mr. Rennick. And Mr. Rennick, you also have Patrick Gallagher sentencing, 24 DCCR 2422.
Yes.
Yes.
Issues, and we had a proper meeting with the feds in early September, late August, for a day. I had informed them that this needed to be wrapped up because of what you had expressed to me in our last meeting. They have followed up with me and said that charges are imminent. And Judge, just to be very straight with you about it, they had told me that in June. And then I'd said, I'm getting heat respectfully from the courts, and she has charges also pending in chambers in Hardin County. The courts are aware of what's going on. Mr. Moran, the assistant U.S. attorney, has informed me that he thinks it's going to happen either, he alluded to me it's going to be in October, but I have no way of telling the court with absolute certainty that's correct. I don't have control over it because I thought it would be sooner.
Right.
But the dilemma for me is, and Mr. Smith, who's been super helpful and accommodating dealing with this issue, is that you know that the federal charges are coming. They haven't landed yet. But I don't want to be placed in a situation where between the state charges and the federal charges are coming. That's why I brought that email.
I appreciate the email. If you don't mind, I'm going to hang on to this.
Absolutely.
I might give Ray a quick email or a call
and
just to
he's
find.
very- he's very
I've known him
pleasant.
we used to work together, so I'm fine with.
I've spoken with him, I've sent him all of the restitution amounts for our cases.
Yeah, and he may be waiting on other.
We had like a 6-hour proper meeting with the U.S. Attorney's Office. We have nothing else to give them.
Right.
We give them everything and everything. It's really just waiting for, he's claiming a debriefing and the charge is coming, but it's taking
Okay.
quite some time.
I'm going to do. Let's do 45 days. Reset, and then I'll email him or give him a call and just see if he can. If maybe that helps, or at least I can find out if it's that they're waiting on maybe other agencies that y'all don't have any, or you don't have any access to, if there's other counties involved.
In the first email that's on there, you might notice that I was getting a feed from Jefferson County, but sees Judge West.
No, I saw, I saw that. No, I'll give him a call and see if I can get some more information, and then we'll hopefully get some answer between now
I
and
know
then.
anything, I'll phone.
Okay, thank you. All right, you're free to go. 45 days. Good morning, Mr. Cole.
Good morning, y'all.
Good. Good morning, sir. Are you Leonard Heidelberg?
Yes.
This is cause number 16-25968. It's the MTRP. I feel like we're waiting on, there was a motion for a competency evaluation,
Yes, ma'am. He filed the
but I don't see that it's been done yet. It's
been done.
it has, we just
Yes.
don't have a report yet.
It should have been e-filed into the case, Your Honor.
The report?
Yes, Your
They
Honor.
sent it to you?
Yes, Your Honor.
Not
Oh.
to me, not to you.
Oh,
I mean,
okay.
I certainly take
Who
Mr.
did
Cole's
it?
word for it, but
Dr. Riggins out of Houston.
Oh,
The court wouldn't pay for his evaluation.
I don't see that it's in here yet.
I do have a copy of it.
Can I see it real quick?
I'll have to send it to your email, Your Honor.
Oh, okay.
Yes.
All this paperless stuff.
Yes, Your Honor.
Finding competent, not competent?
Not competent.
Okay.
not competent or
Dementia.
dementia?
Dementia.
Because I think there's a legal difference.
Yes.
Yes.
Yes, it was dementia.
Okay. Obviously, we need to take a look at that. I'm going to reset it 2 weeks.
That sounds great.
If you will make sure, it should, if you e-filed it, it should be coming through, but if you'll also just in an email forward that report to Ms. Malfino and
Yes.
and that way you guys can take a look at it, talk and see if there's something that you can work out. I can look at what my options are with regard to that diagnosis, and then we'll see where we are in 2 weeks.
And Judge, just so the court is aware, I spoke at length with his probation officer, Ms. Hunter, last week. Previously, when we were here, I believe back in June, you ordered that he not drive, and you spoke with his wife here in
Yes,
court.
yeah.
Ms. Hunter relays that he is complying with all that. She
Okay.
actually comes to his appointments
Good.
with him, and that everything seems to be
Okay.
going well with respect to that condition.
Okay, well, maybe we'll be able to work it out with just modified type probation. We'll see. Okay, all right, we'll see you in a couple of weeks.
Excited about this week.
Oh, me
Aren't you
too.
excited?
I'm so excited.
I can see it all over your face.
Yeah. Good morning, you're David Hatcher. And this is 24 DCCR 2470. I have a memo that this was the last reset for an announcement.
There's a rejection I just forwarded on, Your Honor.
Oh.
And it's pretty non-specific. Any offer that was gonna be made is gonna be a pen time offer.
Okay. Let me get that
We
pulled
were
up.
looking for something vastly different than that, so.
All right,
we're on the
so
same page.
you're David Hatcher. And Mr. Hatcher, you're charged with the third-degree felony offense of intoxication assault with a vehicle causing serious bodily injury from September 24th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment could be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection that you've signed with Mr. Gertz that just shows that any offer the state would make would be for prison time and not for a probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, anything that you guys are waiting on discovery-wise?
Not that I know of. Discovery.
I'm not aware of anything discovery-wise, Judge.
All right, we will get it set on the next available trial docket. Stay in touch with Mr. Gertz. He'll let you know when you need to be back. Thank you. You're free to go. And Christopher Thomas, Mr. Gertz. Good morning. You're Donald Owens. And this is 24 DCCR 1192. Mr. Owens is charged with sexual assault of a child, set for trial to begin with jury selection next Monday. And what is the announcement?
State truth.
All right, then I want to make sure that y'all all understand, obviously after today, no plea agreements unless there is something that comes up very quickly that I'm not or y'all aren't aware of. It is likely to be towards the top of the list since the other old one is gone now. So stay in touch with Mr. Kelly. He'll let you know when you need to be back next week. Okay? All right, you're free to go.
Thank you, Judge.
Thank you. Good morning. You're Naquinda Niclease.
Judge, you're gonna ask me this in sentence, I'm gonna explain now. The reason it's now a probation offer instead of the pen time offer, which originally was based on his criminal history, because he had done a 10-year stretch for robbery starting in 2014. Really, I'm rewarding him because he's tested clean every time since about this time last year, Your Honor. And he's come to court. He's done what the court's asked him to do as far as trying to hire an attorney. I think he ended up still having Mr. Lewis appointed, but I know that he's done everything the court's asked him. Essentially, I'm rewarding him because he's tested clean ever since September of last year.
Okay, thank you. I need your signature. And are we going on count one only?
Yes, Your Honor.
Okay, you're Naquinda Niclease?
Yes, ma'am.
And will he waive the formal reading of the indictment?
He does, Judge.
Mr. Niclease, in cause number 24, DCCR 0478, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of burglary of a habitation from February 5th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State to freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Obviously, you've been doing very well and following all of those bond conditions. Continue to do that. You shouldn't have any issues. And then we'll see you back at sentencing. You need to stop on your way out of the courtroom today and talk to probation, and she's at that desk right there. Okay? We'll see you back.
Thank you, Your Honor.
Thank you.
And just like that, another long day inside a Texas courtroom comes to an end. But the bigger story is what happens after the cameras stop
Did
rolling.
you go through anything with
Some defendants
CPS
walked away
as
with
far
another
as
chance. Others
we have an
walked
order for some
straight toward
CPS
prison
records,
bars.
but was there anything
And throughout
CPS
every
get
hearing,
involved?
you could hear the same question hanging in the courtroom air. Can people really change?
It doesn't look like it.
The
So
judge
maybe
in
that's
these
'cause there
cases
wasn't
balanced
anything.
punishment, accountability, rehabilitation, and public safety all at the same time. Sometimes the court showed mercy.
I would
Sometimes
much
it
rather you
showed
be honest,
zero
but
patience.
and if you're raising, let me
Every
look at
decision
this.
carried real consequences that will follow these defendants for years. What makes these hearings so powerful is that they're not scripted Hollywood drama. These are real people, real victims, real families, and real lives changing in real time.
Okay. So
Now,
how many
I wanna hear
biological
from
children do you have?
Did the judge make the right calls today? Who deserved another opportunity?
One
And
with
who
that.
had
Where are you?
already
And then
used
the
up
other two,
every
or where are
second
they?
chance? Drop your thoughts in the comments below. And if you enjoy
With
real
their
courtroom breakdowns, legal analysis, and
So
intense
this is
hearing
the only
moments like
one you
these,
have.
make sure
So
you
there's no
subscribe
big
and
deal.
turn on notifications.
I mean,
Because
obviously,
the next case might be
you
even
love your
crazier.
stepchildren, but